class, to continue, let us discuss Chapter 2, Crimes Against Popular Representation. So, this is our topic under Criminal Law 2 or the Revised Penal Code, Book 2. Okay? For the record, I would like to state that this reviewer is not mine. I use this reviewer as a basis for our discussion for today. This reviewer is owned by UP, College of Law. Okay? And the purpose, my only purpose is to give you a bird's eye view of the Revised Penal Code, Book 2. Okay? Criminal Law 2 subject. So, to continue, Article 143 or acts tending to prevent the meeting of the Congress of the Philippines and similar bodies. Okay? So, the elements are the following. There is a projected or actual meeting of Congress or any of its committees or subcommittees, constitutional committees or division thereof, or of any provincial board or city or municipal council or board. Okay? So, there is a meeting class. So, the Congress or the councils are in session. And then, second element, offender who may be any person prevents such meeting by force or fraud. Okay? So, it is self-explanatory. Next article, disturbance of proceedings. So, under this article, the elements are the following. There is a meeting of Congress or any of its committees or subcommittees, constitutional commissions or committees or division thereof, or any of any provincial board or city or municipal board or council. Okay? So, the offender disturbs the proceeding of the said meetings. So, offender does any of the following acts. First, he disturbs any of such meetings. And then he behaves while in the presence of any such bodies in such a manner as to interrupt its proceedings or to impair the respect due it. Okay? So, there is interruption as to the proceedings of this body. Next, okay. Next is the violation of parliamentary immunity. So, there are modes in the commission of this crime. First is using force, intimidation, threats, or frauds to prevent any member of Congress from attending the meetings of Congress or of any of its committees or subcommittees, constitutional commissions or committees, or division thereof, or from expressing his opinion or casting his vote. Okay? So, the offender class in this case uses force, intimidation, threats, or fraud. The purpose of which is that the offender is to prevent any member of Congress from exercising his duties and responsibilities like attending the meetings of Congress or of any of its committees or constitutional commission, expressing his or her opinion, or casting his vote. So, take note that offender in mode 1 is any person. Second mode of committing this crime is arresting or searching any member thereof while Congress is in regular or special session. Okay? So, except in case such member has committed a crime punishable under the code by a penalty higher than prison mayor. Okay? So, the elements in the commission of this crime are the following. First, offender is a public officer of or employee. Okay? So, it is essential that the offender is part of the government. Second, he arrests or searches any member of Congress. Third, Congress at the time of arrest or search is in regular or special session. And then last element, the member arrested or searched has not committed a crime punishable under the code by a penalty higher than prison mayor. Okay? So, the Constitution class protects members of Congress. Okay? They are given certain amount of immunity. So, under the Constitution, members of Congress cannot be arrested for offenses punishable by a penalty less than prison mayor or 6 years and 1 day to 12 years while Congress is in session. They can be prosecuted after Congress adjourns. Okay? So, Chapter 3, Illegal Assemblies and Association. So, under this chapter is Article 146 or Illegal Assemblies. Once again, class, there are modes in the commission of this crime. So, the first mode is any meeting attended by armed persons for the purpose of committing any of the crimes punishable under the code. So, the elements are the following. There is a meeting, a gathering, or group of persons, whether in a fixed place or moving. Next, the meeting is attended by armed persons. And then third, the purpose of the meeting is to commit any of the crimes punishable under the code. Okay, so there is organization. There is an illegal assembly in order to commit a crime punishable under the code. The second mode in the commission of this crime is that any meeting in which the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or assault upon person in authority or his agents. Okay? So, the following elements must concur in order for the successful prosecution of this crime. That first, there is a meeting, a gathering, or group of persons, whether in a fixed place or moving. Okay? So, they are meeting each other, class. Second, the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or direct assault. So, when you say incited, it means that the audience is instigated to violate the provisions of the law. Okay? So, who are persons liable for illegal assembly? First, the organizer or leader of the meeting. Next, person merely present at the meeting who must have a common intent to commit the felony of illegal assembly. Okay? So, in the first form of illegal assembly, the persons present at the meeting must be armed. Okay? So, when you say armed, there must be a weapon. Okay? An illegal weapon. But the law does not require that all the persons present must be armed. The unarmed person present at the meeting are also liable. Okay? So, presumptions if a person carried an unlicensed firearm. So, the purpose of the meeting insofar as he is concerned is to commit acts punishable under the revised penal code. So, there is intent to violate the provisions of the revised penal code. That's why the persons gathered together. Then, he is considered a leader or organizer of the meeting. Okay, so those persons can be held liable. Take note, not all persons present at the meeting of the first form of illegal assembly must be armed. Okay? Next article is illegal associations. So, associations totally or partially organized for the purpose of committing any of the crimes punishable under the code. And then associations totally or partially organized for some purpose contrary to public morals. Okay? So when you say illegal association class, the perpetrators are organizing each other in order to commit violation of the code, or such organization class, the purpose of which is purposes contrary to public morals. Okay, so they can be held liable under Article 147 or illegal associations. Okay, so persons that can be liable are the founders, the members of the association. Okay, so public morals, these are matters which affect the interests of society and public convenience, not limited to good customs. Okay? So, wait. So, let's differentiate illegal assembly from illegal association. So, under illegal assembly, there must be an actual meeting or assembly. Okay? In the other hand, illegal association, actual meeting is not necessary. Under illegal assembly, what is punished are the meeting and the attendance therein. In the other hand, under illegal association, what is punished is the act of forming or organizing the association. Persons liable under illegal assembly are the organizers or leaders of the meeting and the persons present. However, persons liable in illegal associations, whether present or not, are the founders, directors, president, and its members. Okay? Now, let's go to chapter 4. Assault upon and resistance and disobedience to persons in authority and their agent. Okay? So, Article 148 or direct assault. So, direct assault class can be committed in different modes. First mode of commission of this crime is without public uprising by employing force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition. Okay? So the elements are the following. Offender employs force or intimidation. Next, the aim of the offender is to attain any of the purposes of the crime of rebellion or any of the objects of the crime of sedition. However, the last element is that there is no public uprising. Okay? So the act class can be done in a private capacity. Okay? So there is direct assault in that instance. The second mode in the commission of this crime class is without public uprising by attacking, by employing force, or by seriously intimidating or by seriously resisting any person in authority or any of his agents while engaged in the performance of official duties or on occasion of such performance. Okay? So the elements are the following. Offender makes an attack, employs force, makes a serious intimidation, or makes a serious resistance. Okay? So there are elements of force class or resistance. Next, the person assaulted is a person in authority or his agent. Next, at the time of the assault, the person in authority or his agent is engaged in the actual performance of their official duty. So this is necessary class that the person in authority is in the performance of his official or actual duty, or that he is assaulted by reason of the past performance of official duties. Next, offender knows that one he is assaulting is a person in authority or his agent in the exercise of their duties. And lastly, that there must be no public uprising. Okay? So the first form of direct assault is tantamount to rebellion or sedition, except that there is no public uprising. Okay? Because if there is public uprising, class, then the crime committed is rebellion or sedition. Okay? Now, classification of direct assault. There is simple and there is qualified direct assault. So, assault is qualified when there is a weapon employed in the attack. Okay? Next, the offender is a public officer. Next, the offender lays hands on a public authority. So, under the law, who is a person in authority? This means that any person directly vested with jurisdiction, whether as an individual or as a member of some court or government, corporation, board, or commission, shall be deemed a person and in authority. So, it means that that person is directly vested with jurisdiction, means the power or authority to govern and execute the laws. Okay? Example, teachers, professors, and persons in charge with supervision of public or duly recognized private schools, colleges, and universities shall be deemed persons in authority. So, in applying the provision of Article 148 and 151 for the other purposes, such as to increase the penalty by reason of aggravating circumstance where a person in authority is involved, the teachers and professors are not persons in authority. Okay? So, class, you must take note that what is important is that said person must be directly vested with jurisdiction or authority to govern and execute the laws. Hence, he is considered a person in authority. Okay? So, when you are a person in authority, then the perpetrator can be liable for qualified direct assault. So, when the assault results in the killing of that agent or of a person in authority, the offense committed is complex crime of direct assault with murder or homicide. The only time when it is not complex is when material consequences is a light felony, that is, slight physical injury. So, direct assault absorbs the lighter felony. Okay? So, the force employed need not be serious when the offended party is a person in authority. So, it qualifies the crime. Intimidation or resistance must be serious whether the offended party is a person in authority or an agent of a person in authority. So, if the public officer is not a person in authority, the assault on him is an aggravating circumstance. Okay? So, these are just matters of reading, class. Now, let's go to Article 152, persons in authority and the agents of persons in authority. So, under Article 207, public officers are defined as any person who takes part in the performance of public function in the government. Okay, so he is endowed with public responsibilities. In the other hand, under Article 152, a person in authority is any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission. Okay? Under Article 152, on the other hand, it defines agents of a person in authority or any person who by direct provision of law or by election or by appointment or by competent authority is charged with the maintenance of public order, and the protection and security of life and property. Okay? So, teachers, lawyers, and heads of schools recognized by the government are persons in authority only for purposes of Article 152 in relation to Article 148 and 151 and in connection with their duties. Okay? So, professors like myself, teachers, they are considered persons in authority class in a limited sense, especially when we are doing our functions as teachers. So, a person in authority includes a barangay chairman and members of the lupong tagapagkasundo as provided under the local government code. So, the status as a person in authority is being a matter of law. Ignorance thereof is no excuse. Okay? Now, let's go to another article, indirect assault. So, what are the elements? So, a person in authority or his agent is the victim of any of the forms of direct assault defined in Article 148. Next, a person comes to the aid of such authority or his agent, and then the offender makes use of the force or intimidation upon such person coming to aid of the authority or his agent. Okay? So, what is important here, class? That the person being attacked in aid, okay? So there is a person in authority, then he is attacked, and then there is another person who wants to help that person in authority, and then that person who aided the person in authority is being attacked. Okay, so the crime committed is indirect assault. Okay, so indirect assault can only be committed when a direct assault is also committed. So, under Article 152, clothes any person who comes to the aid of a person. So, this is a matter of protection also, class, to persons who comes to aid the person in authority with the fiction of an agent of a person in authority. Okay? Next is Article 150, disobedience to summons issued by Congress, its committees or subcommittees, by the Constitutional Commission, its committees or subcommittees. Okay, these are just matters of reading, class. Okay. This violation can be committed by different modes. First, by refusing without legal excuse. Okay, so you did not attend the committee hearings. Okay. Then you can be held liable under this provision. So, by refusing without legal excuse to obey summons of Congress, its special or standing committees and subcommittees, the Constitutional Commissions and its committees, subcommittees or divisions, or by any commission or committee chairman or members authorized to summon the witnesses. Next mode of the commission of this crime is by refusing to be sworn or placed under affirmation while being before such legislative or constitutional body or official. Okay? So, another way in committing this crime is that when you are already there, but you did not take oath. Okay? The last mode in the commission, another mode in the commission of this crime is by refusing to answer any legal inquiry or to produce any books, papers, documents, or records in his possession when required by them to do so in the exercise of their function. Okay? So, hearings, class, are formal procedures. That's why you need to comply. Otherwise, you can be held liable under this provision. So, another mode in the commission of this crime, by restraining another from attending as a witness in such legislative or constitutional body. Okay? So, for example, if you prohibit someone to attend said hearing, then you can be held liable. And then lastly, by inducing disobedience to a summons or refusal to be sworn by any such body or official. Okay? So the testimony of a person summoned must be upon matters into which legislature has jurisdiction to inquire. Okay? Next article is resistance and disobedience to persons in authority or the agents of such person. So, once again, there are modes in the commission of this crime. So, first mode is resistance and serious disobedience. So, the elements are the following. A person in authority or his agent is engaged in the performance of official duty or gives a lawful order to the offender. Next, the offender resists or seriously disobeys such person in authority or his agent. Okay? And then lastly, the act of the offender is not included in the provision of Article 148, 149, and 150. Okay? So if these elements concur, class, then you can be held liable under this provision. Another mode in the commission of this crime is simple disobedience. Okay? So, the elements are the following. An agent of a person in authority is engaged in the performance of official duty or gives a lawful order to the offender. Next, the offender disobeys such agent of a person in authority. Okay? So, this is a matter of obedience, class. Okay? And then third, such disobedience is not a serious nature. Okay? Now, let's differentiate serious disobedience versus direct assault. Okay? So, serious disobedience, person in authority or his agent must be in actual performance of his duty. Okay? In the other hand, under direct assault, the person in authority or his agent must be engaged in the performance of official duties or that he is assaulted. Okay? So, again, under serious disobedience, committed only by resisting or seriously disobeying a person in authority or his agent. Okay? However, in direct assault, they are committed in 4 ways as discussed earlier. And then lastly, the use of force and resistance is not so serious as there is no serious. In the other hand, in direct assault, there is force employed. Okay? So, in serious disobedience, resistance is not that serious and there is no force employed, class. Okay? Now, let's go to chapter 5, public disorders. So, what are the public disorders? So, tumults and other disturbances of public disorders. They can be committed in different mode. Okay? First, causing any serious disturbance in a public place, office, or establishment. Second, interrupting or disturbing performances, functions, or gatherings or peaceful meetings if the act is not included in Articles 131 and 132. Next, making an outcry tending to incite rebellion or sedition in any meeting, association, or public place. Mode 4, displaying placards or emblems which provoke a disturbance of public order in such place. And then, mode 5, burying with pomp the body of a person who has been legally executed. Okay? So, these are just matters of reading, class. What is an outcry? So, to shout subversive or provocative words tending to stir up the people to obtain by means of force or violence any of the objects of rebellion and or sedition. Okay? Next article is unlawful use of means of publication and unlawful utterances. So once again, these are committed in various ways. Mode 1, publishing or causing to be published by means of printing, lithography, or any other means of publication as news, any false news which may endanger the public order or cause the damage to the interest or credit of the state. Mode number 2, encouraging disobedience to the law or to the constituted authorities, or praising, justifying, or extolling any act punished by law, by the same means, or by the words, utterances, or speeches. Third mode, maliciously publishing or causing to be published any official document or resolution without proper authority or before they have been published officially. Then mode 4, printing, publishing, or distributing or causing the same books, pamphlets, periodicals, or leaflets which do not bear the real printer's name or which are classified as anonymous. Okay? So, to be liable, the offender must know that the news is false. Okay? Actual public disorder or actual damage to the credit of the state is not a ingredient of the crime. So, the mere possibility of causing such danger or damage is sufficient. Okay? As long as there is damage, class, then it is sufficient to be held liable under this provision. Okay? Now, let's go to Article 155 or alarms and scandal. Okay? Once again, alarms and scandal can be committed in various ways. First, mode number 1, discharging any firearm, rocket, firecrackers, or other explosives within any town or public place calculated to or which produces alarm or danger. Okay? So, you disrupt the public order of that place by discharging your gun or firecrackers in the middle of the night. Mode 2, instigating or taking an active part in any charivari or other disorderly meetings. Okay? Offensive to another or prejudicial to public tranquility. And then mode 3, disturbing the public peace while wandering about at night or while engaged in any other nocturnal amusement. And then mode 4, causing any disturbances or scandal in public places while intoxicated or otherwise provided Article 153 is not applicable. Okay? So the crime, alarms, and scandal class is only one crime. Scandal here does not refer to moral scandal. That one is grave scandal under Article 200. Okay? So the essence of the crime is disturbance of public tranquility and public peace. Okay? What is charivari class? So it includes a medley of discordant voices, a mock serenade of discordant noises made on kettles, tin, horns, etc. designed to annoy or insult. Okay? So, kanang magsaba-saba, manghapak, mga kaldero, ana. So, that is charivari. Okay? So, what is essential class or the element which is essential and necessary is calculated to cause. Okay? Or which produces alarm and danger according to the correct translation of the revised penal code. Okay? Next is delivering prisoners from jail. So the elements, there is a person confined in a jail or a penal establishment. And the second, offender removes therefrom such person or helps escape of such person. Okay, so these are self-explanatory class. So the person is an escapee. So if the prisoner who escapes is only a detention prisoner, he does not incur liability from escaping if he does not know of the plan to remove him from jail. But if such prisoner knows of the plot to remove him from jail and cooperates therein by escaping, he himself becomes liable for delivering prisoners from jail as a principal by indispensable cooperation. Okay, so these are just matters of reading, class. Matters of reading. Chapter 6, Evasion of Service of Sentence. So, Article 157, Evasion of Service of Sentence. The elements are the following. Offender is a convict by final judgment. There is already a judgment, an order of the court, a decision. He is serving sentence which consists in the deprivation of liberty. Okay? He is a prisoner already. Then, he evades service of sentence by escaping during the term of his imprisonment. So, he is an escapee, class. So, qualifying circumstances as to penalty imposed if such evasion or escape takes place by means of unlawful entry, okay, by breaking doors, windows, gates, walls, or roofs, by using picklocks, false keys, or through connivance with other convicts. So, these are just matters of reading, class. Okay. Next, evasion of service of sentence on occasion of disorder, conflagration, earthquake, or other calamities. Okay. So, this is just a self-explanatory provision, class. You evade sentence by reason of those events. Okay. Next article, other cases of evasion service of sentence. Elements are the following. Offender was a convict. He was granted a conditional pardon by the chief executive. Then he violated any of the conditions of such pardon. Okay? So these are matters of reading, class. Next, let's go to chapter 7, commission of another crime during service of penalty imposed for another previous offense. So, when a person is serving his penalty and he commits a crime, then he can be held liable under quasi-recidivism. So, the elements of quasi-recidivism are the following. Offender was already convicted by final judgment of one offense. And then he committed a new felony before beginning to serve such sentence or while serving the sentence. Example, if the convict killed someone inside the prison, okay? So, what is quasi-recidivism? So, quasi-recidivism is a special aggravating circumstance wherein a person, after having been convicted by final judgment, shall commit a new felony before beginning to serve such sentence, or while serving the same, he shall be punished by the maximum period of penalty prescribed by law for the new felony. Okay? So, the first crime for which the offender is serving sentence need not be a felony. So, once again, class, there is PD 1866 as amended by RA 8294, otherwise known as illegal possession of firearms. We will discuss this in the future. Okay. These are special laws, class, that we will discuss. Okay. Another special law, Human Security Act.